Hello, I'm Jonathan Reed at Reed and Mansfield. I want to talk today about creditors' claims in the probate process. The probate process is the process whereby a will is taken to court and the court supervises the distribution of assets according to the will. Now, the worst creditor claim that we have to deal with in probate is Nevada Medicaid. It would be helpful to pause a minute and talk about the difference between Medicare and Medicaid. Medicare is the government program which gives health insurance to people 65 and older and to younger people who have received a Social Security disability rating. In the context of probate, Medicare never has to be paid back. However, in the context of personal injury cases, Medicare does have to be paid back. But for probate, we never have to pay Medicare back for money they spend taking care of health needs, unless there was a personal injury case involved. Now, Nevada Medicaid is the program that essentially provides for medical coverage for people below certain levels of income. And in the context of probate, Nevada Medicaid always has to be paid back. Occasionally we get a situation in which a person dies after a long illness having received Nevada Medicaid payments, and there will be nothing left for the heirs. Nevada Medicaid does not negotiate. There might be some rare exceptions, but they would be very rare indeed. And Nevada Medicaid will claim against the estate for all money they have spent on the person who died from the beginning of their spending. The upside of Nevada Medicaid is that they get usually huge discounts. So that if a person dies after a lengthy illness, the Nevada Medicaid lien, if Nevada Medicaid paid for their care, may actually be much smaller than expected. In addition, before deciding whether to undergo the emotional burden of a probate, family members can call Nevada Medicaid. We can give you numbers, and they can give you estimates of what lien they will be claiming against the estate. Now, there are some exceptions to Nevada Medicaid. If a person dies with an estate under $100,000 and they leave a surviving spouse or minor children, the court may set aside the entire estate to them without worrying about creditors. Also, you should know that in the event that Nevada Medicaid would eat up the estate, their claim would be secondary to the claim for attorney's fees and costs and the statutory fee that the personal representative would be entitled to. So you will never have to face the situation where after you start the probate process, you're in the hole after paying attorney's fees. That simply won't happen. Provided there are assets in the estate. Now, with the exception of Nevada Medicaid and certain other government claimants, there is a very shortened statute of limitation for creditors to make a claim against the estate. When you file either a petition to set aside or a petition for summary or general administration, which are the probate processes I've described elsewhere, you'll be required to state who the known creditors are, and you'll be required to give notice to the known creditors. With respect to the unknown creditors, in the case of a set-aside for estates $100,000 or less, we don't have to worry about the unknown creditors unless they intervene in the very short set-aside process. Now, with respect to estates over 100,000, where the procedure would be summary or general administration, we're required to publish notice in a local newspaper called Notice to Creditors, saying that the estate's been opened and creditors having a claim should file their claim within 60 days in the case of estates not more than $300,000, or within 90 days in the case of estates over $300,000 with the court. Unknown creditors who fail to file their claim within that time period are barred, and they are just out of luck. So these shortened notice periods are a way to, on the one hand, balance the interest of potential creditors, and on the other hand, balance the interest of the heirs in wanting the estate to get closed quickly. Oftentimes, it is possible for the personal representative, which would be the executor named in the will, or if there was no will, the administrator who was appointed by the court, usually a family member. Oftentimes it's possible for the personal representative to cut a deal with creditors and get a reduction. So, for example, if a credit card company is claiming $1,500 is owed, and the personal representative is in a position to give them $700 cash right now, they may very well be able to settle the claim for the $700 cash payment. In our experience, most estates are not seriously diminished by creditors' claims. Thank you.